First of all, I'd like to remind you about the right structure on how to answer the problem question. It has a very specific structure, and it's very, very important that you follow that. Firstly, you have to discuss the relevant law and make an argument. You have to make strong arguments based on the relevant law and always relevant within the scope of the question. So in this case, if your problem question is about misrepresentation, you should not be too descriptive and just say what misrepresentation is. That's not what the question is asking you. The question is asking you to apply the law to the facts of the case. So every time you discuss a legal principle or a case, you should be able to apply that to the facts of the case and make arguments. That's how you get a first class. Example problem question. Company 1 sells trucks. Company 2 needs a truck for their construction business. During the conversation between Company 1 sales representative with the Company 2 manager about buying a truck, Company 2 was told the following. The truck they had on sale for them only had 10,000 miles covered. However, the mileage was not mentioned in the sales contract. The truck was left-hand drive because it was manufactured in Europe, but the sales representative of the Company 1 assured Company 2 manager that it was legal to drive this truck in the UK. Company 2 bought the truck after this representation is made. Later, it turned out that it was illegal to drive left-hand drive trucks in the UK. Also, Company 1 found out that the truck had in fact covered 20,000 miles and had the mileage reset before purchase. So advise Company 2 about their contractual rights and remedies. What is the first legal issue? You have to state before going into description of the law. The legal issue is potential misrepresentation. So you need to assess the merits of misrepresentation claim on the given facts. During the sales call, Company 2 manager was told that the truck had only 10,000 miles covered, which was not true. Therefore, this could be a basis for the potential claim and misrepresentation. Also, the issue with the law, the relevant law should be misrepresentation, not breach of contract, because the mileage was not mentioned in the sales contract. The facts of the case say specifically that the mileage was not mentioned in the contract. If it was mentioned in the contract, you could do breach of contract claim, but it was only mentioned in the sales call. Therefore, the relevant claim would be misrepresentation here rather than breach of contract. We should be looking at fraudulent misrepresentation or negligent misrepresentation based on the facts. Firstly, before you go into discussing what is fraudulent misrepresentation, what is negligent, and setting out the requirements for this too, you should define what is a misrepresentation and establish that the statements made on the facts of the facts was indeed misrepresentation as required by the law. By the contract law in England. A misrepresentation may be defined as an unambiguous, false statement of fact or law, which is addressed to the party misled, which is material and which induces the contract. So there are 3 requirements. It has to be either false statement of fact or law, addressed to the party misled, so it cannot be addressed to another party. It has to be addressed to the party who was misrepresented, and it should be an inducement. So it has to be material, decisive factor as to doing the contract rather than one small factor. Misrepresentation must be a statement of existing fact or law. The case that I'd like to refer you to is Brennan versus Bolt-Burden. It was argued in this case that if someone makes a legal error and it's suitable, they might be allowed to cancel a contract they entered into because of that mistake. So a legal error can be a basis for setting aside the contract. And the second case, Panhania versus London Borough of Hackney, if someone makes a statement about the law and it was reasonable for the other person to believe it, then that statement can be considered misleading. Application. After discussing the law, it's very important that you apply it to the facts of the case. How do you apply the first case to the facts of the case? It should be argued that if they made a mistake about the law in their statement on left-hand drive trucks being legal in the UK, the contract could be set aside based on that mistake. However, it should be mentioned that we don't know if this was actually written in the contract. All we know is that it was mentioned in the sales call. So if it was not written in the contract, setting aside a contract could be impossible, but we could still bring a claim for misrepresentation. Was it reasonable for company 2 to believe that company 1 when they were represented the truck to be complying with the UK road traffic regulations? That's the second question to answer. Most likely, yes, because they were experts, they were selling trucks. So it was reasonable for the other company who was buying the truck to assume that they know what they are talking about. They should have been experts. They have special knowledge and skill about trucks, and therefore they are expected to take reasonable care and skill when advising their customers about which truck to buy. And this statement was established in the, this principle was established in the case of SR Petroleum versus Marden. You can cite this case. So one more very important tip is that when you write an answer to a problem question, if you want to get a first class, everything you say should be well referenced. You don't need to explain what happened in the case of SR Petroleum versus Marden, but when you say the principle that came out of this case, it should be cited. This case should be in your footnote. The statement must be one of existing fact. This is a requirement. It has to be either an existing fact or law. In this case, there were two statements made. One was about the mileage, which was also wrong, and the other one was about the left-hand side drive. So Khalid versus Carbolic smoke ball statement is relevant here. A statement that's just mere puff, which can be translated as exaggerated talk, cannot be used to accuse someone of lying and make a legal case. It doesn't have any legal power, and the person who heard it can't make a complaint. The more exact the statement, the less likely it is to be seen just as a mere puff. So if the sales representative just exaggerated something that cannot be a basis for a misrepresentation claim, that's for controlling the floodgates of liability. Every single word can be basis of misrepresentation unless it's actually wrong and make the person believe in something wrong that led to suffering financial loss. Otherwise, misrepresentation claim will not be approved. So in this case, the statement about wrong mileage could be the statement of an existing fact, whereas the other statement about left-hand side drive trucks being legal in the UK, that's a point of law. So the mileage is about existing fact, and the other one is about existing law. Misrepresentation must be addressed to the party misled. That's another requirement that should be met for a successful claim in misrepresentation. When the person who made a false statement tells it directly to the person who got misled, or the person who lied might tell someone else about it, hoping that the message will eventually reach the person who got tricked. So this is explained what this principle means in simple words. Citation for this principle is this case, Commercial Banking Co. of Sydney. So when you have a problem question on misrepresentation and you are discussing whether or not misrepresentation was addressed to the party misled, make sure to cite the principle and also cite this case in your footnote. Otherwise, just citing the principle will not be enough. You will lose marks if you don't cite the relevant cases. Here, was the misrepresentation addressed to the party misled? So don't forget to always refer back to the facts of the case after you discuss each principle. Refer back to the facts of the case and apply it. Apply the law to the facts of the case after every single principle, every single case. In this case, yes, company one had a direct conversation with the company two manager. Therefore, it was addressed directly to them. Even if it was through a third party with the intention that it would reach them, it would still be okay, as we saw in the previous slide. However, in this case, it's even easier because they had a direct conversation, so this should not be an issue. Inducement. This is a very important requirement for misrepresentation as well. Lastly, the statement should encourage agreeing to the contract, and it must be an important lie. It should not be just a small thing. It should be something big, something important. And the relevant case that you can cite, Eddington, the misrepresentation need not be the sole inducement, nor it must be decisive. So it doesn't have to be the only decisive factor, but it has to be something important. If you prove fraud, so if it's a fraudulent misrepresentation, inducement is implied. And the citation for that principle is this case, Ross River versus Cambridge City Football Club. So after establishing all these principles that we discussed before, we can conclude that misrepresentation took place. That's the conclusion. However, we don't know yet, we haven't discussed yet what kind of misrepresentation it would be. There are 4 types of misrepresentation. There is fraudulent, negligent, the statutory one, and innocent misrepresentation. Negligent misstatement is the Hadley-Byrne principle. That's common law negligent misrepresentation, and there is also the statutory one under Section 2 of the Misrepresentation Act 1967. The difference between the two is that the statutory misrepresentation is easier to prove, whereas the common law negligent misrepresentation requires proof of this special relationship principle established in the case of Hadley-Byrne. And there are not many reported cases that successfully established special relationship under the Hadley-Byrne principle. So the most relevant here would be either fraudulent misrepresentation or the statutory one, statutory Section 2 Misrepresentation Act 1967. However, it's a good practice if you have time, because on the exam, you are under time restraints. So if you have time, it's always good to discuss all 4 of them and discuss what is the likelihood of each of them succeeding on the facts of the case. So, for example, it's highly likely that fraudulent misrepresentation would succeed on the fact that they lied about the mileage. If they deliberately lie about the mileage and they reset the mileage before selling the truck, that sounds like fraudulent misrepresentation. The likelihood of success for on Hadley-Byrne principle is low, but you could still discuss it and say arguments as to why it is less likely for Hadley-Byrne principle to succeed in this case. Fraudulent misrepresentation. For this, you need to prove fraud, and in practice, it's very hard to prove fraud. It would be good to mention that in your answer. The relevant case is Derry versus Peake. Lord Herschel made 3 main points. To prove fraud, you need clear evidence of it. So you need to prove that they deliberately lied to make a gain. Fraud is proven if they lied on purpose, said something without thinking it was true, or didn't care if it was true or false. Just having an unreasonable belief doesn't automatically mean fraud. It just shows that the person might be dishonest. The dishonesty shows fraud, and in this case, when they reset the mileage, that shows that they lied on purpose. So it could be fraudulent misrepresentation. If fraud is proven, the motive of the person guilty of it is immaterial, and inducement will be implied too. Application. Could you establish fraud? As we said about resetting the mileage, it would be more applicable to establish fraudulent misrepresentation, and you could say that the likelihood of fraudulent misrepresentation is higher because it seems like they did it on purpose, they changed the mileage on purpose, and then they lied about it. So it's quite obvious. Whereas for the second one, for saying that the left-hand drive vehicles are legal in the UK, it could be negligent. We don't know exactly if they said that on purpose. Alternatively, it could be negligent misrepresentation if fraud cannot be proven. So if for whatever reason the court says that there is not enough evidence for fraud, then the alternative would be to make a claim under Section 2 of the Misrepresentation Act 1967. The main idea of this rule is that if someone tells a lie or commits a misrepresentation, they have to pay for any harm it causes unless they can show that they have good reasons to believe the lie, misrepresentation, was true when they made the deal. Application. After discussing what Section 2 is about, you should apply it to the facts of the case. Negligent misrepresentation is easier to prove than fraud. Therefore, if there is insufficient evidence for fraud, they could rely on Section 2 misrepresentation instead to claim damages. For resetting the mileage, it would be fraudulent misrepresentation that is more applicable here. However, for the left-hand drive trucks being legal in the UK, it could be negligent, depending on what were the intentions. So is there any evidence that they knew that it was not legal, but they still deliberately lied? If that's the case, then fraudulent misrepresentation would be more relevant. But if it was negligent statement, then Section 2 would be more relevant. For further information, I suggest that you have a look at our contract law study materials. So before we finish, I'd like to tell you a little bit about how we can help you with your legal studies. At SimpleStudying, we have a team of content creators and tutors who are successful law graduates, having achieved 2-1 and first-class degrees in universities such as LSE, City University, BPP, Keele, University of Leeds. We're not associated with these universities, but we hire the best graduates. In addition to the ready-to-go first-class study materials that we have on the platform, we offer tutoring for personalized support. So it's one thing that you have all the study materials you need to get high grades, but it's another thing that when you have this kind of one-to-one Zoom meetings with a tutor who will guide you with every step with your legal studies, whether it's preparing for an exam or helping you with a coursework. We help with courseworks by helping the student understand how to do correctly the legal research. I can't emphasize this enough, how important this is. If you know exactly the strategy of how to do correctly the legal research, it will save you so much time. We start doing the research together, usually on one-to-one tutoring, and make notes of the applicable law. And then we help students understand how to follow the ARAC structure and the issue rule application conclusion. We help students have the correct and clear structure, essential for the high grade. Structure is very, very important for getting a first class. Unless you have crystal clear structure for answering problem and essay questions, you're not going to get a first class. We teach students the art of argument making. Making arguments is the hardest task that most of the students are struggling with, and it doesn't come with just 1 hour or 2 hours of tutoring. It's continuous hard work, and we help students get there. We teach you in the least time possible how to do these arguments, what is required from you to get a first class based on strong arguments. How can we assist you to prepare for an exam? What we usually do is we ask for past exam papers from your exam, from your university, and then we help you select topics to revise and draft an answer to a problem question or an essay question on the selected topics. And then we help you learn how to answer those problem and essay questions. This is usually the best way to maximize your chances of getting the first class on an exam, even if it's an in-person exam where you have to memorize everything and you don't even have a right to take notes. This is the strategy that has helped so many students from SimpleStudying get very high grades, including first class. As you can see on our reviews, we have so many students who get a first class, especially if you get 6 hours plus one-to-one tutoring, you're highly likely to get a first class per exam or coursework. If you want to be the next student to get a first class, please join SimpleStudying now. Thank you very much for your attention.